Well, good evening to all the aspiring advocate on records and wishing you all the best. May I request my colleague Rajiv Datta to set the ball rolling. Mr. Rajiv Datta, please.
Thank you, Tuliji. Uh, I also want to welcome all of you to today's lecture. Good evening, everybody. It's uh, it's very heartening to see that today the number of people who are sitting for this exam is growing with every year, and of course, not forgetting that last 2 years, almost 2 years, have been a step back. I think all of you who have chosen to sit in this exam are, I mean, the most important thing is anybody could practice in Supreme Court. We all know any advocate can appear in the Supreme Court. But to practice as advocate on record in Supreme Court is, according to me, a unique experience. So therefore, at the outset, let me briefly tell you that after you become an advocate on record of the Supreme Court, you will be entering into a very uh, a different arena. You are already advocates, and now, of course, with the advent of new rules, which of course were not there when we sat for the exam, you have already had several years of experience in appearing in the courts, also filing. But I must tell you, in the beginning only, that working as an advocate on record in Supreme Court, and perhaps you may know or may not know that I was an advocate on record of the Supreme Court for about 18 years. As I said, it is a unique experience. And it is not only unique, it is a very different kind of an experience. Why is it different? Let me give you a small example. You know, the Supreme Court of India, building wise, is located in such a place where from where in 3 kilometers you have a district court, trial court, and you have the High Court. High Court also is a trial court on the original side. And we, all of us almost, who working in Supreme Court, some of you may not be also, you may be um, aspiring to come to the Supreme Court only after becoming advocate in the court. Within these 3 kilometers, you can see how our courts, the three different facets work. You can just go across to Patiala House and see how trial courts and what is the nature of work, how it is conducted, how advocates conduct themselves. Similarly, if you go a little ahead, then there is High Court, Delhi High Court. You can also see how the High Court works. Therefore, let me tell you that once you will become advocates on record, I wish all of you success. It will be a different experience. We all aspire to do good work, but to work efficiently as an advocate on record is, as I said, unique experience, but it's also a very challenging experience. Already, you must be preparing for this exam, and of course, otherwise also, if you have been filing petitions in the Supreme Court, you must have seen the Supreme Court rules. You must have studied. So, I may also say that we are not going to at least I'm not going to lay much stress on, you know, the actual rule, where it is applicable, etc. You will have to study all that. But what is important here is you are sitting in an exam. Exam has its limitations. It is just a step to get you into the actual framework. It has its limitations. Paper has to be set in such a so that you can answer the questions in the limited time given to you. So the limitations. What I expect from you is that those of you who are very serious of becoming advocates on record would in any case be prepared not only to write this exam but to and their aspirations go much beyond, and that is to actually effectively become an advocate on record in Supreme Court.
Increase the volume.
The host is confirmed their side.
So therefore, it was very important for me in the beginning to bring out this fact that there is a lot of seriousness required in your practice when you become an advocate on record. I'm not saying that otherwise you're not serious in your work, but this will entail something which at the back of your mind will always be that this is the last court for your client. There is no court after this. And what petition you choose, what arena you choose for your client to file his petition is going to determine their future. And there's nothing after the Supreme Court. That is the unique factor in your practice because there is no appeal from Supreme Court. I may also say, and I may add, that let me also inform you in my run, as I informed you that I was advocate on record for 18 years. Judges in the Supreme Court are very, very much aware of what kind of petitions are presented by which advocate on record, because they day in and day out go through petitions prepared or will be going through which you will prepare. And I must tell you, once I was in the court of Justice Rumapal, she issued a notice in a petition only because she said, I am very happy the way this petition has been done. Now coming to the brass tacks, let me at the outset say that working of any court is governed by the jurisdiction conferred on it and the procedure laid down in respect of such court. You must be already aware that there are procedures which you must have already dealt with, like the Code of Civil Procedure, the Criminal Procedure Code, and must also be aware of the inherent powers of the court. That concept, which a court or a tribunal can exercise where there is no rule of law or given matter or procedure. You are aware of the fact that High Court is conferred with the powers for framing procedure, rules, etc. for the trial courts, district courts, subordinate courts. The High Court has both the administrative and judicial powers to do that. And jurisdiction is what grants prima facie ability to the court to entertain a dispute. The next important thing for you to know is that courts can always rule with regard to their jurisdiction. No jurisdiction of the courts is exercised mechanically. But there is one rider. All jurisdictions are amenable to fresh and emerging needs and demands. There is always a scope for making innovations, and you will see from the time the Supreme Court has said the rules, the first rules which were framed and the rules which exist today, there is a lot of new, new things that have been introduced. You are all aware that Article 145 confers powers on the Supreme Court to make rules. What do rules do? The rules regulate the practice and the procedure of the court. Only when the rules are framed, I think the President of India requires his consent is required. When we are talking of the jurisdictions of the Supreme Court, we all know the Supreme Court has appellate jurisdiction. It also has extraordinary appellate jurisdiction. It has original jurisdiction. It has advisory jurisdiction. What we both have decided between us is that I will speak with you about the appellate jurisdiction of the Supreme Court, and my learned colleague here will speak on the other facets of the jurisdictions. So to talk of appellate jurisdiction, you know Articles 132 to 134A, how an appeal can be filed in the Supreme Court in civil matters, criminal matters, and also the rules which govern and regulate as to how those petitions and on what ground those petitions will lie to the Supreme Court. I don't think the purpose of this lecture is to give you the grounds, etc. But what we have in mind is to convey to you that the various types of jurisdictions which are conferred on the Supreme Court have to be exercised in a regulated manner, and that is done by the rules. And also, one more thing you people have to keep in mind, the court of which you are going to become advocates on record has unique and very, very important powers. Article 141 for that matter, appellate power, which carries with it the power to issue directions binding on all the courts. Then Article 142, for doing complete justice, the Supreme Court can pass any order. So these are very, very wide powers of the Supreme Court. And of course, coming to one of the most invoked powers of the Supreme Court, that is Article 136. Article 136 is something which you have to explain to your clients, because they come to you in the Supreme Court thinking that you are going to file another appeal. The client may have already exhausted his right of second appeal before the High Court. But when he comes to Supreme Court, he thinks it is just another appeal. Whereas that is not the fact. Special leave petition, in the words which are used in Article 136, itself explain that it is not an ordinary appeal. It is special leave to appeal. And what is the speciality in that appeal? That is for you who will draft and bring it before the court. Substantial questions of law. Not only substantial question of law, but of general public importance. Very, very meaningful words. And you will have to time and again grapple with these, because as I said, and you know, it is the most invoked jurisdiction, and it has almost become a fashion that whenever a person loses in the High Court, he wants to move the Supreme Court. A lot of burden will be cast on you and on your shoulders when you will read the case and find there is really no case made out. and still the client is insisting that you must file. And we have this, phrase that let us take a chance. Let the court decide. And of course, there are experiences and experiences. Courts have also entertained matters which we ourselves feel there's nothing in the matter. Now, there is something which is very, very important that you must also know, that the Supreme Court also has appellate powers which are conferred by certain statutes. So apart from Article 132 to 134A, of course, 134A, by a certificate from the High Court. The Supreme Court also has powers, appellate powers, under Section 2 of the Enlargement of Criminal Appellate Jurisdiction. And Article 136, you already know, is guided by Rule 21 and Rule 24 of the Supreme Court rules. Then, which is very, very important for you to know, and you will grapple with throughout your career, is the doctrine of merger. Whether the order of the Supreme Court, one word dismissed, is a speaking order or not, or is it a non-speaking order? And when you acquaint yourselves with the law that the court has laid down in this regard, you will be doing a yeoman service in helping the court in deciding the matter. One very important factor that you have to keep in mind is, when you bring a dispute to the Supreme Court, it is an adversarial dispute. But very, very successful advocates are only those who provide a solution. And that solution you can provide within the draft that you present to the court. When I said, Justice Lumapal said, I am issuing notice in this matter only because the way and manner in which it is drafted, that is the precise point that she had in mind. That look at the way in which it has been presented. Let me shift the gear a little to some other aspects which you will find are unique to Supreme Court. Of course, even the High Courts have power under 226 to entertain public interest litigation. But this is something all of you will be dealing with very extensively in your career. How the filing of the public interest litigation is regulated, because by now a lot of water has flown under the bridge. There was a time when, of course, letters can be entertained by the court. We know it, but the rules have now been specifically framed. And what are the conditions which are laid down for you to first follow strictly when you file a public interest litigation? Because if you don't follow them, you'll be wasting the time of the court. We all know that Supreme Court is a court of record. What is a court of record? Article 129 provides that it can punish for its own contempt. The Supreme Court has the power to transfer certain cases. You already are aware of that. Section 25 CPC, Section 406 of the CRPC, Article 139A of the Constitution. There are also special powers of the Supreme Court under Section 11 of the Terrorist Affected Areas Special Courts Act 1984, where very intelligently they have used the word expedient in the interest of justice. I am not going to say anything more, but these are things which you have to focus on. In fact, what I am trying to convey to you is, when you sit in this exam, are already aware, and you have to, the purpose is not only passing this exam, the purpose is to become a good advocate to support the Supreme Court in discharge of its functions. May I now request my dear colleague to take this forward?
Well, thank you, Rajiv. Uh, Let me also start, let me take a page out of his presentation, which is beautifully done. Let me start from generality and then come to specifics. You want to be an AOR, please take a pause. What's your importance? You are the custodian of rule of law. Sovereignty vests in the Constitution and it's exercised through institution of legislature, executive and judiciary and some other autonomous bodies. And you are the person who has to ensure that rule of law prevails and the sovereignty as exercised by Constitution uh, is pervading everywhere. Uh, One thing you must not forget is that you are an officer of the court. So there would be a situation where interest of your client would clash with your need to be an officer of the court. And every time being officer of the court should prevail over just tying yourself with the interest of the client, because you will build your face value. Face value is not, everybody says face value is important. It is vital, and there is a question of face value, but who gets the face value? Who appears regularly before the court, is diligent, he's honest, does his brief, takes his brief seriously, irrespective whether he's senior or junior or advocate on record, he builds a face value. Some person just appears and says one thing, the court believes it. Other person appears and something court does not believe it. So therefore, to build up the face value, you need to be an officer of the court and not to forget that. You have to decide the right remedy for your client. Horses for courses is very important. And before you start drafting anything, you must have a knowledge of the substantive law and the procedural law like Supreme Court rules. If you don't know the substantive rules, the substantive law, drafting will not be effective. And if you know the procedure on the substantive law only and not the rules, then also you can stand to lose. Uh, you must realize your importance that you are the pivot of running of the Supreme Court, um, uh, because nobody else can appear in the court, senior or any non-advocate on record, without your authority, and that's very vital. You must understand that the court only recognizes you and nobody else. That's why the need to have an office within 16 kilometers. uh, you must also know what rules are there. Getting the case fixed is the biggest challenge for you, because arguing is one thing, but getting it fixed is also there. And each Chief Justice has his own different rules of fixation of matter. So you must be currently aware of that, because Chief Justice and Chief Justice, it may vary, and you have to be kept yourself abreast of that. Now, having said these general things, coupled with just a supplementary to what Mr. Rajiv Datta said, let me talk about the original jurisdiction. There are almost about 10 jurisdictions on the original side. First is the writ petition, Article 32, extraordinary original jurisdiction. The Article 32 guarantees this writ petition as under the part 3 as dealing with the fundamental rights. It lies against the state, and except the habeas corpus does not lie against any individual party. These fundamental rights given under Article 19 are subject to limitations that set out in the Constitution, and you must be made yourself available that what are those limitations of public morality and sovereignty and other law and order. We must keep it in mind that although 32 is granted, but load has forced Supreme Court to say that please take recourse to Article 226 first before coming to Supreme Court. That's direction by the Supreme Court by way of expediency, but wherever necessary, they can take it up also. Article 32 forms a part of basic features of Constitution and cannot be amended even if there is a 100% Parliament desiring to do so. Existence of alternative remedy normally prohibits the Supreme Court to entertain, but in appropriate case they can take time in the matter in spite of they can take the matter in spite of alternate remedy being available. Similarly, normally disputed questions of fact are not entertained in writ jurisdiction, but in appropriate case, Supreme Court may entertain the writ petition. There cannot be any writ petition against a constitutional court, either Supreme Court or High Court. Against a Supreme Court order, only remedy would be review and thereafter curative petition as set out in Ashok Hura's case. This is because people still felt that to err is human, and if something is left out as right of hearing or somebody is uh, interested in some particular thing and or some questions have not been there, but then there are certain rules which have to be followed in that particular situation. That is, you cannot take any ground other than what has been taken by the review. That's important. The principle of constructive res judicata would apply unless matter is dismissed in limine or in some other technical grounds. Uh, in pill situ issue, which Mr. Rajiv Datta has taken, the issue of locus standi is very important. There is no statute of limitation governing the writ petition. However, since its equitable remedy based upon principle of delay defeats equity, normally the writ is entertained within the 3 years, and if beyond that, the delay has to be explained. The writ petition allows constitutional torts as a remedy under public law without affecting the right of party to file a suit for damages in their personal capacity. The fundamental rights can be suspended under Section 359, but the rights under Articles 20 and 21 are non-derogable. It is after the ADM Jabalpur case that this was brought in. To summarize, Article 32 is heart and soul of fundamental rights. Writs of habeas corpus, mandamus, quo warranto, certiorari prohibition, and etc. Only on proceedings of the High Court on the administrative side are amenable to the jurisdiction under Article 32 and not the main judgments given on the judicial side. Second kind of original jurisdiction under 131 of the Constitution of India is the dispute between Union of India and state versus state, and at that level. And in this Article 12 is not important, the states have to be there. Private parties cannot be made a party to it. The corporations cannot be made a party to it. And even the Article 12, wherever we deem it as a state, would not come here. Normally, there should not be any dispute because of the union list, the state list, and the concurrent list should lay down, uh, uh, should mitigate the litigation, but still, case to case, it comes in. In this case, it has to be based upon a constitutional right or a legal right. Merely a commercial suit between state to state would not lie. This suit is not in the nature of a suit in civil procedure code. Uh, Article 262 is an exception to Article 131, where water disputes are referred to adjudicated by a specially constituted tribunal under the Interstate Water Disputes Act. And latest amendment which is there is that have a permanent uh, tribunal to handle all water tribunals, but it has still to become an act, but it's already moved in the court and is pending consideration. Then third kind of original is the original jurisdiction is the disputes relating to election of president and vice president, where only exclusive jurisdiction is given to Honorable Supreme Court under Section 71. Then most important is that the President of India under Article 143 can seek opinion of Supreme Court on some important aspect of a fact or of a law, in which at least 5 judges would sit to give that advice. And in this particular thing, there are several uh, judgments which have passed on this, except for one judgment I find that it is not the final decision. High courts are supposed to follow this, but Supreme Court can always challenge this because the affected parties don't get a right to examine or to cross-examine. And they only, the opinion is given on the basis of the query asked by the President of India and nothing more than that. And therefore, after the opinion, the somebody has to challenge the concerned statutes or other things if one wants to take it to logical end and not just rely upon the Supreme Court advisory opinion. But it's basically to uh, bring the contours of the impact of a particular statute or a fact to the knowledge of the president for him to take an effective decision. Then the original jurisdiction, my learned friend has already covered that jurisdiction of Supreme Court to transfer petition under Section 25 of Code of Procedure, under Section 406 of Code of Criminal Procedure, so I did not touch that. Under 139A, Supreme Court has jurisdiction to withdraw the cases to itself from all the high courts if, in case it thinks it's important. And then under Section 11 of the Arbitration and Conciliation Act, Chief Justice nominates an arbitrator for an international dispute, which is taken more on the administrative side and not the judicial side. Therefore, this cannot be subject to uh, a petition for SLP. Then contempt jurisdiction of the court is very vital. As my learned friend has already said, it's a court of record and shall have all the powers to such courts, including the power to punish for contempt of itself. And under Section 317, Public Service Commission of members can be removed and suspended.
Removal, right.
Removal. And as already my learned friend has said, Article 142 goes beyond everything else as it covers the extraordinary powers to do complete justice. This, in nutshell, covers the original jurisdiction. Now, I would just like to say some more things from the rules. One is that General Clauses Act shall apply for interpretation of these rules as it applies to interpretation of acts of Parliament. Second is that no advocate other than advocate on record for a party shall appear, plead, and address the court for a matter unless he is instructed by advocate on record or permitted by the court. As I've already said, that he should have his office within 16 kilometers, and more than anybody else, you are aware that 4 years have to go by before you can appear for the exam. Now, this is important that every advocate on record shall keep such books of account as may be necessary to show and distinguish in connection with his practice as an advocate on record. Number one, monies received from or on account of and monies paid to or on account of such of his clients. And two, the monies received and monies paid on his own account. The time when Mr. Darji Datta and I paid for our exams, there was a paper of accounts training us in that how to keep it. Please don't forget it. You can lose your license if you don't maintain your books as per this requirement. This is very vital and don't forget this. Every pleading should give bare facts, chronologically, one idea in one para, and no evidence to be given with that, no case law to be given that. The principles of the Civil Procedure Code would apply here also. You must know that what can registrar do, what can a single judge do, what can a division bench do, what can a three-bench judge do, and what can a five-judge bench do. Three judges are required if it's a question of death sentence. Five judges are required when there is a question of law, substantive legal issue, and therefore five judges are required. Punishment less than 7 years, bail can be granted by single judge, and number of things registrar itself can do. So you must know that what remedy and before which court what is to be done, and what should be the seriousness of your effort. Because arguing before division bench is one thing, but arguing before three-judge bench or arguing before five-judge bench requires a different kind of deep analysis, very clear and crisp thinking, and uh, being very clear about propositions of law which you will be giving to the judges. And then the inherent power is not only Article 142, but also in rules dealing with inherent power. Supreme Court has the power to do away with any rule and then take up a thing. So inherent power in rules and inherent power in Article 142 is all pervasive, and Supreme Court is very vital. And this in a nutshell is what I wanted to say. Uh, Over to you, Rajan.
Yeah, just to add a little.
Go ahead, please.
You see, when you will practice as advocates on record, there are many practical things which we can also tell you, which will come your way, and they are not to be totally ignored. Everybody will have a different experience, quite right. But what is the duty cast on an advocate on record when he's in different situations? We have faced all those situations, therefore we can tell you. And let me tell you, if you look at the rules, they will provide what you have to do as an advocate on record. For example, if an affidavit comes to you, which is signed by somebody who you have not seen, how to take further steps. There will be many situations, many situations. And I want to add also with regard to advisory jurisdiction, the Supreme Court is cast with a number of in its jurisdiction, in the advisory jurisdiction, a number of things, a number of advisory jurisdictions. My learned friend has referred to some. One of the advisory jurisdiction which I want to refer. There's a reference under Section 257 of the Income Tax Act, and the Supreme Court needs to answer that. And then reference under Order 44 of the rules by central government or statutory tribunal under the statutes. There is one other very important advisory jurisdiction conferred on the Supreme Court is the reference by the governor under Section 17(1) of the RTI Act. And that is very important according to me, because of the prevailing today, the circumstances in which we are passing today. Even reference under section 14(1) of Right to Information Act is cast on the Supreme Court. Of course, a reference under Article 317(1) removal of UPSC members has already been referred to. Presidential reference under 143(1) also has been referred to. I would say that there is nothing in these rules which is unimportant for you. And in any case, your aim should not be only writing this examination, but in accomplishing something more than that. That is, at this juncture in your life, when you are trying to become, see, when you become an advocate, as an advocate, you are a part of the Supreme Court, or the whole legal structure in this country. But when you become a advocate on record, it is like you are getting into a framework. What is expected out of you is, in my opinion, whenever you get a case which you feel is a frivolous case, it is a duty cast on you not to fight. How you will achieve this is your inner conscience and nothing else. Because let me tell you, friends, it is very important for us, because let me be very frank, as far as my practice was concerned, it was my only source of livelihood. So therefore, there are certain compulsions which we have to overcome over a period, and an advocate on record in the Supreme Court, therefore, according to me, has to perform functions and adhere to norms which are not normally being practiced by advocates other than advocates on record. See, there was the long-standing, there were solicitors, etc., etc. You are not just becoming, you see, when you become a solicitor, we all know what is the aim and purpose of that. But as becoming a part of the Supreme Court as an AOR, it is your first prime duty. Of course, nobody gives you an oath. In the medical profession, they give an oath and they call it a Hippocratic oath. I don't think we need an oath, but you must give an oath to yourself that you will not do anything which will hamper or unnecessarily waste the time of the Supreme Court. And in every petition that you get, try and excel. Therefore, I think with these words,
I'll supplement what my friend has said. Uh, 2,000 of you are preparing for this exam. We wish all of you success. But some of you will make it, some of you may not be able to make it. But net, whatever you have studied is not going to be lost. You are all going to gain by that. So you are going to be a positive gainer on this. And therefore, as suggested by my learned friend and as suggested by you, please, before you start doing anything, start drafting anything, study the law first, then study the rules, then draft it, and be the master of your facts. As long as you're master of facts and you have done study of the law to the best of your ability, the deficiency of any, the judge will fulfill himself because he's also equally interested in justice. But mastery of the facts is very, very important. Person like Bhulabhai Desai and all the top lawyers are master of the facts. Even now also you will see some of the seasoned lawyers saying, your lordships, please may not open the file, but let me tell you the facts. So it helps. So do it like that. Our advisory is not only confined to rules, but also the conduct that is there. And again, please don't forget it, you're officer of the court first, then anything else. And wish you all the best. And
I just want to
yeah,
add one thing in the end. We have now entered into a very different arena, in a different age. Now e-filing is being done. There are rules pertaining to that in the Supreme Court rules. You have to follow them. In fact, you are all more equipped with computers than our
I
people
don't
from people from our age. We initially we did not even know how to send an email. So all the best to all of you, and please make yourself familiar with every rule. The interesting part of our profession is that we learn every day. It is not as if you can grasp and learn and mug up everything in one go. Every day will be different, and that's the biggest fascinating facet of our profession. Thank you very much.
Thank you so much.
All the best to every one of you. Thank you very much.
God bless.
God bless.